Good morning. Assessment Appeals Board is hereby called to order. May we do roll call, please?
Board Member Sisk,
I'm present.
Board Member Little,
Present?
and Board Member Curtis is absent, so Board Member Little will be acting as Vice Chair today. Thank you.
Thank you. We will do the Pledge of Allegiance now, and if you do intend to give testimony today, please remain standing so that you can be sworn in afterwards. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And remain standing if you would like to be sworn in by the clerk.
All right. Raise your right hand. You do solemnly affirm that the testimony you are about to give in the matter now pending before this board will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated.
All right. Before we do the agenda review, I think I'd like to have council explain to the participants today regarding a two-member board and the procedure.
No board may have a hearing unless there's a quorum present. There is currently a quorum present of 2 members. However, if any party wishes to have a 3-member board hear their case, they can request that, and the clerk will let us know if the 2-year waiver would expire before the rescheduling of the case. We'd ask that the party enter into a 2-year waiver. If they refuse to enter a 2-year waiver, then their case would be heard today with a 2-member board. In the event that there is a tie vote, because we have only 2 members, we would ask that each party stipulate that the absent member, Vince Curtis, can review the proceedings. There will be a video recording and hard exhibits entered into, and participate in a future deliberation to decide the case in order to avoid the need to do a do-over. If a party is not willing to so stipulate, then we'd have to hold the entire hearing from scratch. So we'll ask each party as they come forward if they're willing to stipulate to the absent member reviewing the record and the evidence in the event there's a tie, just to get that on the record.
Thank you. All right, we're going to go forward with an agenda review, and then after that, I'll go through the entire agenda. If your case is being heard today, if you would, at that time, just give me an idea of about how long your presentation will take, and then I'll go to the assessor and see how long their presentation will take, and then we will start hearing cases. So right now, we're just reviewing the agenda.
Great. So, item number 5, agenda review for November 2nd, 2015. The clerk of the board recommends approval of the agenda review by the Assessment Appeals Board. The agenda review consists of the following items. It's going to be fairly short. Item number 30, application number 14-10311, applicant PEGH Investments, LLC. We're going to continue that to December 7th, 2015, pending receipt of original stipulation. Item number 32, application number 14-10594, applicant Entertainment Earth Holdings. We're going to continue that to December 7th, 2015, pending receipt of original stipulation. Item number 48, application number 14-11296, applicant John A. and Janet K. Czar Trust. We'll remove that from the agenda due to submission of a withdrawal. And item number 55, application number 14-11373, applicant NRFC Ventura Holdings LLC, removed from agenda due to submission of withdrawal. That completes the agenda review.
I move to approve the agenda review.
I second.
Okay, hearing no objection, motion carries. Thank you. Yes.
To approve that, you hear anyone else?
All right. It looks like items 6 through 8, 9, 10, and 11 are all the same applicant. Is there a representative present?
Good morning. Robert Slavin, attorney for the applicant.
Good morning. Are we going forward on these cases today?
This is a request for continuance. There's a Superior Court action that needs to be resolved, and we'd like to have the Assessment Appeals Board hearings trail that judgment, anticipated judgment. And the applicant is willing to sign waivers to the statute of limitations.
All right. To the assessor, any objection?
Kent Meyer, Ventura County Assessor's Office. Just have a question as to how long it'll take for the Superior Court judgment to come through, if you're aware.
Sure. Unless there's a stipulation, there's a trial date in March of
How long will the
2016.
court case itself last?
I'm sorry?
How long do you think the court case will last?
I don't believe it's going to go to trial. I believe there will be a stipulation, and stipulation could be as early as 30 to 60 days from now, but there is a trial date in March.
Okay. I do not object to any continuance and would prefer to go sometime after the court case if possible.
Yes.
The clerk would just like to ask the agent for clarification purposes, does the court proceedings directly affect the valuation of the assessments?
It affects the ownership of the parcels, and because it affects the ownership of the parcels, it therefore affects the valuation.
Okay. Generally, the Chairperson Little, when there is Superior Court action, the timeline to hear cases is actually told until that's completed, and we don't have to schedule those for hearing until we get the court order. So we would just recommend to indefinitely continue these once the Superior Court proceedings are resolved. It's the party's responsibility to notify the clerk, because then basically when there's Superior Court proceedings, the timeline to resolve the appeal is frozen, and then once it's resolved, the timeline starts again. So we would just recommend continuing these to an undetermined date, and then once either of the parties notify us of completed court action, we will schedule these for a new hearing.
All right. Sound agreeable to the applicant?
Absolutely. In fact, once we have a stipulation or judgment, we will immediately contact the assessor's office to try to resolve the issue.
Very good. Okay with the assessor?
Just want to know if there's any docket number on this?
There is, and I'll supply it to the clerk of the board.
Thank you. And is there a copy of that for the clerk? or-
There is. I only
Okay.
have one copy for the clerk.
Very good. Thank you. Appreciate it.
Sure.
Appreciate that. All right. Just for the record, I will read the application numbers. 12, 12749 through 12, 12751, 13, 11949, and 13, 11950, and 14, 11112. Those are all of the applications that I will need a motion to have an indefinite continuation until such time as the court action is resolved.
Thank you very much.
And do you have a motion?
I so move, yeah.
Okay.
And members of the
And-
board, I apologize for my dress today. I'm just back from vacation
Oh.
and have not had an opportunity to go home.
Not a problem. Okay, I have second. And I vote yes. Hearing no objection, motion carries. Thank you, sir. Thank you, Assessor. All right, it looks like items 12 through 25 are grouped together.
Yes.
Would you identify yourself for the record, please?
Don Mosley with Wiffenden Law Group, agent for the applicant.
Thank you.
And I would estimate an hour, maybe an
all.
hour and 15 minutes.
1 hour. And to the assessor?
The assessor is prepared to move forward. We estimate 20 to 30 minutes for our presentation. And it's a penalty assessment, therefore the assessor has the burden of establishing the basis for the imposition of the penalty assessment.
Okay, Assessor Burden. All right, once I finish going through the agenda, we'll come back to you.
Okay, thank you.
The clerk
I just
must,
want to clarify for the record that the assessor has requested findings of fact on this matter, and then we also need to see if both of the parties would stipulate to be heard by 2 board members.
all right. Any opposition to the hearing having 2 board members as opposed to 3?
No, no.
And is there a stipulation that if there's a tie, the absent board member can review the record of the proceedings and vote after reviewing the record?
Yes, we're fine with
Yes.
that.
And the assessor agreeable?
The assessor is agreeable.
Okay, thank you, thank you. All right, items, let's see. All right, items 26 through 29, Henning Trust. Anyone present?
This is a request to vacate stipulations previously approved by the appeals board on April 20th, 2015. The county auditor controller returned those to us because there was a issue with the values, and they requested that the assessor correct the errors and reissue. So the revised stipulations are have been provided to the board to review. I believe the issue was that there was the wrong enrolled values. The assessor could clarify that if needed. So we would need the board to vacate, first make a motion to vacate the stipulations approved on April 20th, and then, if they agree, approve the revised stipulations.
All right. First motion to vacate the prior,
I so move.
okay. I will second. Motion carries, and we do have those here for signature. All right, and I will need a motion to approve the revised stipulations.
I so move.
I second. Hearing no objections, motion carries. And pressure, yes. Lot to do up here. And that is items 26 through 29, applications 13, 12316, 13, 12317, 13, 12320, and 13, 12321. All right. Taking care of 30. Now, item 31, application 14, 10348, Connie Steps.
Yes.
Good morning. Are we going forward on this case today?
We'd like to continue this. Situation is there was an assessment roll correction done for Ms. Steps, and it's been processed by our office, but has not gone through the entire cycle with the auditor, controller, and tax collector's offices. So we'd like to
Okay.
postpone this to February 29th if possible.
22916, is that agreeable with the applicant?
Yes.
Very good. To have a motion to continue to 22116?
I think it's a 229.
29.
29.
Is that okay, Brandon?
Yes, that is
Okay,
it.
I so move.
Okay.
I second.
Okay, thank you.
Thank you. Hearing no objection, motion carries. Okay. Item 33, application 14, 10936, Lynn Schatz, SCHATZ.
I don't believe anyone has checked in for this item this morning. Therefore, the clerk would be recommending denial due to lack of appearance.
To have a motion to deny due to lack of appearance?
I so move.
I second. Hearing no objection, motion carries. Okay. Agenda items 34 through 35, applications 14, 11139, and 14, 11141, Museum of Ventura County. Good morning.
Good morning.
Are we going forward on this case today?
No, we would respectfully like to ask for a postponement.
All right. And would you identify yourself for the record?
Yes, I'm Kevin McAtee, agent for the museum.
Okay, thank you. To the assessor?
The assessor would like to request that we receive all information from the applicant no later than December 2nd and have this continued to January 11th.
Is that agreeable
Yes,
with the applicant? All right. To have a motion to continue to January 11th, 2016, with the proviso that all information be supplied to the assessor's office by December 2nd, 2015.
I so move.
Is that agreeable with the applicant?
Yes, it is.
Okay. All right.
Thank
I
you.
will second the motion.
Is it letting you? I'll put it in manual.
Okay.
Please vote.
Voting's done. Hearing no objections, motion carries. Thank you. It's approved.
You could please pass out the exhibits for item number 36.
All right, agenda item 36, application 14-11160, holiday retirement. Good morning.
Good morning, how are you?
Fine, thank you. Would you identify yourself for the record?
My name is Bobby Curley. I'm with Grant Thornton, an agent on behalf of Holiday Retirement.
Okay,
This is a request to amend the application to include in section 6, or sorry, in section 6, B2 has been selected, and they are requesting to amend or correct the change in ownership date from 1/1/2014 to September 26, 2013. I believe that's what the agent is here to do.
That is correct.
2013,
Yep.
September 26th. All right, and that's the only change on
That's the change, yes.
Okay. Any objection from the assessor?
No objections. We've already had discussions regarding this issue.
Okay, very good. To have a motion to approve the change in the application for item 6B2 to read September 26th, 2013.
I so move.
And I second. Hearing no objections, motion, you want to vote? Computers were supposed to make us faster.
All right, so
Motion carries.
So now,
Okay.
because amendment was approved, there's a requirement that there's a minimum of a 45-day continuance unless the parties stipulate to a shorter amount of time.
All right. Have you discussed a date for hearing?
We were looking at February 29th. However, on this specific case, all information was supposed to be supplied to the assessor no later than October 3rd, and he's been giving it to us piecemeal, and there's still some information that we're still requesting.
Okay.
We believe that we've submitted what we could so far. We're working to get everything else for the assessor's office, but we can continue to work and gather more information for you if possible.
All right, you want to set another date to have the information supplied to you by?
December 2nd at latest.
December 2nd?
Second.
Is that agreeable with the applicant?
That is agreeable, yes.
Okay. So a 45-day hearing date?
I think the party, or the assessor suggested February 29th. That meets the threshold of more than 45 days, and is one of our available hearing dates. So February 29th is acceptable if it's okay with the agent.
That is correct, that's fine.
Fine with you? And to the assessor, that's okay with you?
That's fine.
Wonderful. To have a motion to continue to 2/29/16 with the proviso that all evidence that the assessor has requested be delivered to their office by December 2nd.
I so move.
I second. Any objections?
Please vote.
No. Hearing no objection, motion carries. Thank you.
This
Thank you, too.
agent also has the next item.
Okay. Agenda item number 37, application 14-12223, NIC 12 Simi Hills Holiday Retirement. Okay.
We have been submitting additional information for this case as well. It makes sense that it would be heard with the previous case that we just discussed. We're prepared to discuss today, but if the assessor moves to have it on the same date as the previous case, we're happy to do that as well.
Are these two different economic units, or can they be heard separately or together?
They're separate economic units.
Okay.
So we still are in need of some more information from the agent. So we'd like to have all data due by December 2nd and have the continuation date February 29th so that both cases can be heard the same day.
All right. And that's agreeable with the applicant?
That is agreeable.
To have a motion to continue to 2/29/16 with the
Aye.
proviso with all information requested by the assessor be delivered to their office by 12/2/15.
I so move.
I second. And hearing no objections, motion carries. Thank you. Thank you to the assessor. Right, moving right along, we have agenda items 38 through 47, applications 14-11249 through 14-11258, Charter Communications.
Good morning, board members.
Good morning. Would you identify yourself for the record?
Renee Daza, agent for the applicant.
Good morning. And are we going forward on these cases today?
No, we're respectfully asking for a continuance of the appeal. We provided the assessor's office with a lot of information. We're working with them actually on several of these personal property appeals and trying to get them as much of everything we can. So we're asking for a continuance. I'm not sure if there's a date in mind, but we're thinking maybe December, I guess. 7th, I think we're back here again.
I believe we continued your 2013 cases to February 29th.
Oh, February, I'm sorry, that's right.
Right, December, what is the date that he just requested? I don't have the right calendar. December 7th is a hearing date, but it's kind of packed.
That's right,
I believe
yeah.
you're here, but you're also going to be here on February.
In
or
February.
your stuff has been continued to February 29th as well, so our recommendation would be February 29th, 2016, if that's okay with everybody.
And to the assessor, any objection to the
No
additional?
objections to the continuation, but I believe we may be needing a little bit more information. I'm not positive. Yeah, we still need a little bit more information on these cases. So we'd like all the data due by February 2nd, by December 2nd.
December 2nd,
Not a problem.
if there is. Okay. All right. Do you have a motion to continue to February 29th, 2016, with the proviso that any additional information requested by the assessor's office be delivered by December 2nd?
I so move.
I second. Hearing no objections, motion carries. Thank you.
Thank you.
Thank you to the assessor. Item 48 was withdrawn. Items 49 through 54, applications 14-11320 through 14-11325. Mackle Wallace Development. Good morning, sir. Would you identify yourself for the record?
My name is Thomas Mackle, owner and manager of the property. I request a postponement at this time due to the fact that we have it's a shopping center and Hagen's is in bankruptcy, and we should know about by December 15th, they're telling me, the disposition of that. And that's really tied us up for the last 3 months, actually 6 months since they took possession of the property. And we would like the time to meet with the assessor and discuss some of the problems. We're in a flood control district, which is affecting the value of the property, and I'm not quite sure, what all the rules and regulations are for this, and I'd like to try to get that straightened out. I thought I could do it prior to for this meeting, but because of the complications on the shopping center and the bankruptcies and so on, it's kind of thrown us into a problem situation. We want to work with the assessor. We think that we can work everything out with him. That's our side. We really haven't had any discussions with him at this point. But I do believe, in fairness, we can do this.
Okay. To the assessor,
We do not object to a continuance. However, we have requested the information from you in email format, and we have not received all that information, so we'd like all information due by December 2nd.
Could we make it by December 15th, please? Because we'll have more information on the Hagen situation and so on. Some of the information that they're asking for, I'm I can't pledge that I can deliver all of the information that they're asking. So I have to find some time to sit down with them and see exactly what this information means.
And you have some court cases,
Right.
court appearances to go for on the Hagans before you can get that
Well-
information?
No, we will not be going, it's all in the bankruptcy court right now. I mean, our bankruptcy attorneys, it gets so complicated that I don't quite understand all of this bankruptcy proceedings, but they have given us dates when they will know further information.
Okay, and that's the December 15th
Yes.
is when you'll have that.
Under those circumstances, I'd like to go ahead and request the information due by December 21st. Give them a few more days to actually look it over,
21st.
and a continuance to February 29th.
And does February 29th, 2016 work for you?
Fine, thank you very
Okay.
much.
All right, do I have a motion to continue to February 29th, 2016 with the proviso that all information that the assessor's office had requested of the applicant via email be supplied by December 21st, 2015?
I so move.
Thank you.
And I second. Hearing no objections, motion carries. Thank you. Thank you to the assessor. And item 55 was withdrawn. Item 56 is application 14-11445, Los Robles Hospital, HCA Healthcare. This had been postponed from 6/22/2015.
No one checked in for this item this morning. This agent had several other items previously on the agenda that they resolved. So the clerk, the board is recommending denial due to lack of appearance.
Do I have a motion to deny due to lack of appearance?
I so move.
And I second. Hearing no objections, motion carries. Items 57 through 58, applications 14-11468 and 14-11469. Tatiana, I will spell the last name.
Shturkova. Good morning.
Good morning. Would you identify yourself?
My name is Dmitry Shturkov, and I'm agent for Tatiana.
Very good. Thank you. Are we going forward on this
Yes.
hearing today?
Yes.
And about how long do you think you're
I need
presenting?
about 5-6 minutes to present my documents.
And to the assessor,
If the assessor is prepared to move forward, we estimate about 10 to 15 minutes.
10 to 15.
And is the applicant okay with only being heard by 2 board members today?
Yes.
And
Yes, we
if
are.
the board has a tie vote, are you agreeable to having a 3rd board member review the
Yes.
record after the fact? All right. So the
All right.
assessor, same question?
No objections.
Okay.
We would recommend this be first since it's so short, and then we'll get into the longer hearing second.
Okay. All right, we'll come back to you as soon as we go through the rest of the
Thank
agenda.
you.
Thank you. All right, agenda item 59, application 14-11493, Ali, I'll spell the last name, Moradnouri.
I don't believe anyone checked in for this item. It was last heard on June 22nd, 2015. It was continued today without the applicant present at the last hearing because of medical issues. I had corresponded with their son, and they were there was back and forth communication, so they were aware that the hearing had been continued today, even though they weren't present at the June 22nd, 2015 hearing due to medical issues. No one has checked in this morning, though, so we would now be recommending denial due to lack of appearance.
Yeah. I'd also like to note that there was a notation that there was a proviso that there be no further continuances for the applicant on the last hearing date. So do I have a motion to deny based upon lack of appearance?
I move, yes.
Second? You want to vote? Want to vote on the screen? There we go. Hearing no objections, motion carries. All right. Item 60, application 14-12224. I'll spell the first and last name, Mahnaz, last name Jadidolahi. Good morning. Would you identify yourselves for the record, please?
Mahnaz Jadidolahi.
I'm her daughter, Tanya Barhodar.
Thank you.
This is a request for reconsideration, so the clerk will be handling this. We think it's a quick and easy thing, so if the board's okay with it, I think we can go into it right now.
Okay.
Just before we get started, is the applicant okay with only 2 board members hearing
Yes.
the reconsideration? All right.
And if we have a tie, Mr. Curtis can review the records and vote.
Sure.
Right, so, pass out the applications. Okay, I'm just gonna pass out my talking points. All right. This is a request for reconsideration of the Assessment Appeals Board's decision on August 3rd, 2015, denying Appeal 14-12224 for lack of appearance. A hearing notice was mailed on May 29th, 2015. The clerk of the board did not receive a confirmation of appearance, nor did the applicant appear at the August 3rd hearing. On September 17th, 2015, a request for reconsideration was submitted by the applicant. The applicant has stated they did not receive the notice of hearing, which was mailed to the applicant at the address provided on the application. Pursuant to Property Tax Rules 326 and 313A, and the Assessment Appeals Board's policy titled Reconsideration of Denial for Lack of Appearance, which states, good cause shall be defined to be one of the following. 1, applicant or agent failed to appear because of circumstances that were beyond the control of the applicant or applicant's agent, and the applicant or agent could not appoint someone to make appearance on their behalf. Or 2, the applicant or agent had no knowledge prior to the hearing that he or she would be unable to appear as scheduled. A copy of this policy was mailed to the applicant with the notice of reconsideration hearing for today. I can also provide copies if the applicant or any board members wish to review the policy. If the board believes the applicant has met good cause for reconsideration, the board's motion can vacate the August 3rd, 2015 Assessment Appeals Hearing Officer's decision to deny, oh, no, I made a typo. That was the Assessment Appeals Board's decision, not the Assessment Appeals Hearing Officer. Assessment Appeals Board's decision to deny lack of appearance, and make a second motion scheduling the valuation hearing to a future date. The clerk is informing the board that we did send a notice of hearing as required. We would like to, since the applicant is under oath, we just would like to confirm that they did not receive their notice of hearing. Is it correct that no notice of the August 3rd hearing was received?
Yes.
So they've now sworn under oath that they did not receive it. Or the clerk's recommendation would be that the board grant the reconsideration request.
Okay, any questions from the assessor of the applicant?
No questions. We just need them to know that they need to contact Rick Denham regarding this case. We have his business card here.
Okay. And just to confirm, your address is 3817 Hartling, Hartling Court in Newbury Park?
Hartung, Hartung.
Oh, okay. Clerk has that. Do you have
Maybe
the
that's why.
corrected?
That's why.
Maybe that's why.
Mm-hmm.
But I received the letter saying that we didn't appear, so I don't
Yeah.
know.
Did you correct?
Yes, on your application, it is spelled correctly, but I was
Yeah.
reading from the notice of hearing.
Okay.
That's why.
But I received.
I did not notice that before. Yes, you're correct. We did make a typo, so that could be why it wasn't received. They did receive the notice of reconsideration hearing, which we also mailed to the wrong address, but
Yeah.
it looks like this may have been our fault. I did not realize before now that we misspelled that, so even
Oh,
more
it is.
reason.
It's wrong on here too.
Yes, okay.
I didn't notice that either.
All right.
It is, it's spelled wrong.
If the board, if the board feels that the applicant has provided good cause, do you have a motion to reconsider the application?
I so move.
And I will second the motion.
If we
And
didn't get this
voting?
one either, we wouldn't have never known.
No objections.
It's
Motion
okay, we
carries.
fixed
And
So
would we
should-
like to set a new hearing date?
Yes. Yes, please.
Correct. So we can continue the now evaluation hearing to either January 11th, 2016, or February 29th, 2016.
February 29th, please.
2/29/16 to the assessor. Is that agreeable?
That date is agreeable.
Okay. And is there any information that the assessor needs to have on record by December?
If they have any data that they'd like to present to us, we'd like that by December 2nd.
Okay, and if the applicant has any information, like an appraisal or something like that, if you could supply that to Mr. Denham by December 2nd, that would be,
The address fixed now?
Yeah, they fixed it.
I have notes to update our records. Regardless, unless you resolve the matter with the assessor's office, you'll be back here at 9:30 a.m. on February 29th, 2016.
Okay.
So we'll send you a confirming letter, but this is also, your formal notice. But we will update the address
Oh,
on the
okay.
record.
I
Thank
got
you.
it, 9:30 a.m.
okay. Now I need a motion to continue application 14-12224 to February 29th, 2016, with the proviso that any requested information be supplied to the assessor's office by December
Thank you.
2nd.
I so move.
Nice second. Voting is complete. No objections. Motion carries. Thank you. All right, and finally, agenda item number 61, application 14-12241, Bolt Enterprises. Good morning. Would you
Hi.
identify yourself?
Hi, I'm Edward Shillo,
Good morning.
Chairman Little,
Yes.
Board Member Sis, good morning.
Good morning.
I am the controller accountant for Bolt Enterprises. It's a building, commercial building in Oxnard, and I'm here for a reconsideration.
Mr. Schiller, are you agreeable to being heard by only 2 board members?
Yes, sir.
Okay, and if they don't agree on the decision, are you okay with having a 3rd board member examine the record after the fact?
Yes, sir.
Okay. Since this is reconsideration, we recommend going into this right now. Is that okay with the chair?
That's fine. We've got the application here.
All right. This is a request for reconsideration of the Assessment Appeals Board decision on August 3rd, 2015, denying appeal 14-12241 for lack of appearance. A hearing notice was
Thank you.
mailed on May 29th, 2015. Subsequently, the clerk of the board received a hearing date confirmation notice from the applicant on June 22nd, 2015. The confirmation of appearance was executed on June 18th, 2015 by Edward Shillo of Bolt Enterprises LLC with a selection made of "I will be present," which is the first option. The applicant did not appear at the August 3rd hearing. On September 3rd, 2015, a request for reconsideration was submitted by the applicant. Property tax rules 326 and 313A and Assessment Appeals Board's policy on reconsideration of denial lack of appearance state, good cause shall be defined as one of the following: the applicant or agent failed to appear because of circumstances that were beyond the control of the applicant or applicant's agent, and the applicant or agent could not appoint someone to make an appearance on their behalf, or 2, the applicant or agent had no knowledge prior to the hearing that he or she would be unable to appear. A copy of this policy was mailed to the applicant with their reconsideration hearing notice, but I do have printed copies if anybody wants to review it. As clerk, I certified that the notice of hearing was mailed to the address provided on the application, and we believe because the agent returned confirmation of appearance that they did receive that notice of hearing. Is that correct, Mr. Schillo?
Yes.
Okay. We have not been presented any, what we believe, a reason that meets the board's good cause definition for reconsideration. So our recommendation is going to be that the board deny the request, but the applicant does have the opportunity to plead their case to the board if they believe they meet the board's good cause reconsideration requirement.
Okay. Mr. Schillo.
Thank you. I understand those rules. But before I start, though, I do want to recognize the assistance from the Assessor's Office of Bradley Scott and Brendan as well on the phone. Thank you. What I want to do is just explain what happened to me regarding the August 3rd hearing. I did receive the hearing date confirmation notice, and I sent it back in, but in my mind, because I did not receive a confirmation of my response, I did not attend the meeting. It was my mistake. I now understand that no confirmation is sent. I have never appeared here before this board before, and I guess I was unfamiliar with the procedures. In business, I always do a meeting, and it's always, I get a confirmation back. I got a confirmation for this hearing. I also want to add that as an employee of Bolt Enterprises, I will, of course, be getting a personnel evaluation, and the results of this hearing will affect my job performance evaluation. And so I am here, and I want to say that I'm sorry that I missed the other meeting, but I'm asking for your help, indulgence for my mistake, so that my mistake does not affect my employer. Thank you for your consideration.
Okay, to the assessor's office, was there any communication going on with the applicant?
I don't believe we'd had any communication with the applicant or with the agent prior to the hearing date. We did send out a 441D request, which was not responded to. If the board determines to go ahead and reinstate this application, we would like all information no later than December 2nd.
Absolutely. I totally agree, if I get a
But,
chance.
But we actually would object to any reconsideration in this case, simply because of the fact that he did return the confirmation notice and he does not have reasonable cause for not having appeared that day.
Okay, and this is a decline in value application.
I'd already prepared 6 copies, a very short summary of my presentation. Just asking the board's indulgence for my mistake as an employee.
The board members can, deliberate in closed session if they prefer, or right now, or they can trail their decision to later if they're not comfortable making a decision right now on the spot.
Okay. Going back to when you signed your hearing confirmation notice under certification, when I sign something, usually I mark my calendar. So was there any, medical issue that had come up that prevented you from?
No, I cannot
Marking
honestly
the
say that.
calendar.
I mean, I read the document, there's a lot of, I don't have a good excuse.
Okay.
It's really my mistake, and I really am asking for the court's indulgence, the board's indulgence here, because it is a mistake that I made. I mean,
All right.
that's what happened. So I understand the rules, and I understand the board, though, does have its discretion. I'm hoping that you'll take into consideration my personal situation as an employee in this matter.
Okay. All right, the board is now deliberating. There is, good cause is defined as the applicant or agent failed to appear because circumstances that were beyond the control of the applicant or the applicant's agent, and the applicant or agent could not appoint someone to make the appearance on their behalf, or the applicant and agent had no knowledge prior to the hearing that he or she would be unable to appear as scheduled. So number 2 falls by the wayside, so it's just a matter of, was it beyond the applicant's control? Any?
Yeah, that's a tough one. I
Meanings.
mean, he filled out and returned the confirmation card.
Yeah.
So that's kind of the confirmation.
Does the board have any discretion beyond just those rules that I made a mistake?
The board does. However, the property tax rules are what binds this board, and we sign an oath that we will abide by the board's rules. So I do not feel that the good cause has been met. The burden is on the applicant to prove to the board. So I will move to deny the reconsideration. We'll see if the motion carries.
I second.
Okay. Motion has been made and voted. Hearing no objection, motion carries, and I do apologize, but we will deny.
I understand.
Okay.
Can I just ask
Thank
a
you.
couple questions really quick before I go?
Yes, to the assessor.
Well, no, I just, at the very beginning in the morning when I was here, was Ken, was your name? I'm sorry, I
My
didn't
name
catch
is
your name.
Kent.
Kent, I'm sorry. Kent?
Kent Meyer.
Thank you, Kent. And then, is there any procedure by which I can further appeal the reconsideration? For example, to the assessor himself?
This board is a quasi judicial board, and if you want to file an appeal, it would have to go before Superior Court at that point.
Great. Again, thank you for your time. Thank you for your public service.
Thank you.
Have a good day.
Okay.
Mr. Schiller, just to clarify, you did file an appeal for 2015, and let's see.
So I will be back.
Right,
And
so
I'll,
this, your appeal that was just denied was for the base value transfer of the property, correct?
not a transfer, the property's been owned by the same entity for many years.
Okay, hold on.
It's a 2014 we were just talking about today, and I did file a request for the 2015 assessment.
All right, give me just a second. I think
Yeah,
you
that-
may have additional recourse to pursue that this year. Sorry.
Because I have an appeal already on the 2015?
Right, so, okay, so your 2014 appeal was for the September 1st, 2014 interior construction completion, is that correct?
That's right, it was, I'm just appealing the supplemental.
Right, okay, so, because it's within the first 4 years of that event happening, you can modify your 2015 application to cover that event for 2015 forward. So I recommend contacting me in a few days, and I'll help you draft the letter to the board that you need to modify your application. And so your application for 2015 can be modified to include the base year value for new construction for 2015 forward. That way, only the short 2014 window will be locked in, and your permanent base value won't be completely off the table. So you can appeal that for 2015 forward.
That's great, thanks for pointing out that exception, I appreciate it, Brendan.
So if you want to take my card, and I'll work with you. So you're not completely, the board just won't be able to reduce 2014 to 2015, but they'll, if they find in 2015 that the construction was valued too high and reduce it, the base year would apply to 2015 forward.
Mm-hmm, okay.
Okay?
Thank you very much.
Very good. All right. Thank you. Thank you, Brendan.
That be all?
Thank you very much.
Thank you again.
Okay. All right. We've made it through the agenda. And first, we'll be hearing items 57 and 58. And then
So
we'll,
we ready to go into that now?
yes.
So if you guys would like, you can come sit up here at the table and get comfortable.
And the door, you just push the door open.
Corner. Open. Have a seat in the middle preferably. Okay, these are your exhibits. When you wish to speak, push here, you bring right up the line, and that means we can hear you. Okay? Don't hand it out yet.
Okay, this is agenda items 57 through 58, applications 14 11468 and 14-11469.
I just want to clarify before we get started, neither party is requesting findings of fact, is that correct? Are you requesting?
Actually, I did request, yes.
Oh,
Okay,
let me review my record. Oh, yeah, the applicant did request findings of fact on the application. Do you have a payment available today?
I will make it today, yes.
Okay, the applicant just needs to pay me before the end of the hearing. I believe his cost is gonna be $150. Yes, so
Right.
the applicant will need to provide me with payment of $150 prior to the board announcing their decision.
okay, and so the applicant knows that if the process goes in your favor at the end of the hearing, if you do not want those findings of fact, you can also rescind your decision
Yes.
at that point. So, okay.
So generally, we'll start with an overview from the assessor's office with the facts of the assessment and what is under appeal today.
Okay, go
Morning.
right ahead. Thank you.
Kim Meyer, Ventura County Assessor's Office. This is a situation where the applicant had informed us of a change of ownership, or we discovered a change of ownership via the recorder's office. After we worked the change of ownership, the applicant called us and said there was a land contract signed months before that. So we changed the date of the change of ownership via an assessment roll correction. It is a single-family residence. It is not owner-occupied, and we did not accept the stated purchase price in the land contract. So the burden of proof, we would like the board to determine who has it.
All righty. Thank you. Okay. Okay, so the first thing we have to find out is who carries the burden of proof, and then that tells us who goes forward on their presentation first. This is a single-family residence, correct?
That is correct.
However, it's non-owner occupied. It's a rental property
No,
for
it's
you?
owner-occupied.
It's owner occupied?
The assessor thought it was not owner-occupied.
Okay.
The application has a box checked on it.
Then we will accept the burden of proof on this.
Okay. The assessor has the burden.
I just
Okay.
want to clarify, this doesn't appear to have a homeowner's exemption, and the code says that should be the defining factor. Is this your only residence in
Yes,
California?
it's our only residence, yes.
Okay.
Hmm.
Is there a reason you haven't applied for a homeowner's?
I think it's a misunderstanding because in my property tax bill, I can see I have a 7,000.
Okay, then maybe it's just in this year they didn't.
Yeah,
get the
maybe,
exemption.
yeah, I'm not
Okay.
sure.
Okay.
And
sorry
I
about
believe
that.
the code says that it just has to be eligible. It doesn't say that it has to have one.
Right, but if another property was getting the exemption, that would be their primary place of residence, and this would qualify. So that's just what I was trying to get at. Sorry, I do see on the tax bill that they get the exemption, so it is the owner's primary place of residence. Sorry.
Okay, so you do have the
Yes.
homeowners. Good. Okay, how the hearing will continue on is the assessor will make their presentation. After they're done with their presentation, the applicant will have the opportunity to ask the assessor any kind of questions that they might have regarding their presentation. And the board will ask some questions as well. And then you will make your presentation as to the value, and then vice versa, the assessor will ask you questions on your presentation. Okay. Thank you.
Before we get started, I noticed that maybe you're about to clarify, so I don't see one application of the listed, is each application being heard separately?
It's, I was going to address that in
Okay,
my
sorry.
opening, sorry.
Okay.
Rick Denham, Ventura County Assessor's Office. Good morning, members of the board. This property was transferred, I believe, through land contract on April 30th, 2012, and that was the agreed-upon date. And this transfer was not an open market transaction. It was not listed through a broker or put on any recognized local real estate board. When it transferred on that date, the applicant at the time of application stated that they paid $215,000. The assessor's office assessed the property at $260,000 on the date of transfer. And the reason this case is kind of going to dictate the rest of our cases. If you sustain the assessor's office, then we can maybe discuss the future cases. If you were to lower it, it would change the assessment in the future through Prop 13, and that would become more of a mathematical exercise than a debate, because we all have to follow Prop 13. So that is maybe the confusion that Brendan was worried about. But basically, the first case is sort of the whole thing, and then after that, it's kind of academic, in my opinion. So basically, this property, once again, was transferred on April 30th, 2012, and the disagreement, as I understand it, is that we assessed it for $260,000, and the applicant purchased it for $215,000. And our largest objection is that it wasn't a fair and open market transaction. The next page I'm going to refer to are my comps on this page, okay? The assessor's office provided 3 comparable sales. All of these sales are from the subject neighborhood. They're all what we refer to as model matches. They're all within 0.2 of a mile of the subject property. And the subject is located in River Park. The subject and all of the comps have Mello-Roos fees associated with them, and that's, of course, very important. Our price ranges went from $259,900 to $264,900. We came in at $260,000, and that's why we came up with $260,000 as opposed to the $215,000 that the client purchased on the land contract without the benefit of open market sale. On the next page, I have the plot map, and I apologize for the primitive version of it. Our maps were limited in this area, and it shows the subject and the 3 comps relatively close by. And from that, we concluded that $260,000 should have been the fair market value of the property, and that is really our entire case. Thank you.
All right, thank you. Are there any questions from the applicant to the assessor?
Yes, I do have a question. Why you actually including 3 new homes sales by builder? It's a new homes previously not occupied. And this is a primary market. Well, I'm buying a home which we actually bought house which has been used before. So I don't think it's fair to compare used houses and new houses. It's like you buying a car in the dealership, right? And when you're trying to, buy used car, the same model, same year, it's going to be completely different price. Same here. All houses are coming in completely different conditions. Some of them, here and there, I can say, or someone remodeled and maybe having an even bigger price. So these 3 houses which you are referring to, it's a first-time sale from builder. It's not from...
Okay, we'll go with
Thank
that
you.
question.
Thank you. I think I got the gist of the question.
Okay.
River Park has been a very unique experience for all of us, and I'm very familiar with it, and it's sort of slugged along up and down. And where are you on the ladder? And believe me, I've spent a lot of time. If you notice, all of these homes have the same year built. And they did sell, even though they were made in 2009, They've sold over several years because of the outstanding real estate market that hit along 2008 or right around there. And that's what happened. And our best reference is, what's going on at that time. When I look to upgrades in both the subject and the comparables, they were similar. The builder, fortunately, it doesn't translate out on this form, but they tell us, and it's a percentage, like usually between 2 and 9 and whatever. And we were actually probably a little higher in upgrades. And I realized that somebody had been in the house before, but basically we're trying to say what we're buyer. At that time, his model was available. It did sell through a builder. A builder under Rule 2 is considered an open market sale, and we can only use open market sales. And these were available. They have a very distinct pattern, and it looked to us like that would, if his was available, that would be about the odds that where his would go. And we chose the comps. A, they were close by. B, they were a model match. And C, they were open market. So that's why we chose them.
Okay.
I do have a question. Actually, I believe some information you provided is incorrect. Such houses, one of them has been built in 2011 and 2 others in 2012. The land was completely undeveloped. We can look for the actual documents and you will find houses came to the market in 2012, except one which has been actually built in 2011 in December and sold in January. So please verify your information.
Would that be your comp number 3? That sold in January?
Mr. Myers has the computer. He's going to
I'm sorry, I don't remember exact date for
Okay,
each
he's-
house, yes, but when I did my research, I actually looked for all these 3 houses, and I find out they've been constructed in 2012 and sold in 2012. Because River Park area, especially this type of houses, actually has been built in phases. So first phase was 2008, then 2009, and so on, until the last portion close to Oxnard Boulevard. So it's...
Okay.
You can even look through the Google Maps and see, if each year it's undeveloped area, then start construction, then, how it's built.
Okay, the assessor is researching
Please.
to see when the construction was completed.
On the comp sheet, we have all of these as effective years. That's when the properties were designed and construction started for the tract. Comp number 1 was actually built in 2012, Comp 2, 2012, and Comp 3, 2011.
So
That's
it's
when
not
the construction.
2009.
That's when the construction was completed, but it started before then.
Okay. So,
So it's a brand new houses came to the market in 2012, right? So we can't compare these new houses, brand new houses, with house which has been built in 2009. It's a used house, not a new one. How you can, it's kind of very strange.
But we also have no evidence that the value is anything less than what these homes are selling for. Do
Well-
you have any well, we'll get to your
Yeah,
evidence in a moment.
okay.
Yeah, I will
Okay.
present my information later.
Yes.
Thank you.
Okay. Are there any other questions about
No, not now.
their maps? Okay, now we'll hear, any questions from the board?
I do. Did you just say that the comps 1 and 2 were built in 2012 but have an effective year of 2009?
Correct. It's based on when they were designed as far as the effective years for these purposes. So when we're building out a brand-new tract, it might take 3, 5, 6 years to build, but when the design was made, it's more for the functional issues. So they're all designed about the same time. The construction is completed at different times.
Are you talking effective year or effective age? I mean, you have year down, but, the conversation is effective age.
Our policy is put the effective age based on when the property was designed and construction started.
Okay, so it should be effective age. And you're saying the home that is 3 years old has an effective age of a 6-year-old home, which means that it's been used twice as long?
Used twice as long? Well,
You couldn't, okay, sorry. Okay, never mind.
Okay, we might hear more from the applicant on that issue. And a question to the assessor. The floor plan remained the same on the subject property as the comparables?
Correct.
Okay. All right, we'll hear from the applicant now.
Chairman?
Yes.
Before, point of clarification, The assessor's market evaluation page compared to the last GIS map, are the comparable numbers matching up with the comparables as listed on the market evaluation? It looks like
Does not look like it, no.
number 1 is actually number 3, and then I'm not sure if 2 and 3 are right or not, so we need to get the record properly reflected if it's incorrect.
Oh, I see what you're saying.
Column 2 is right, and 1 and 3 are switched.
Correct.
Okay, so just to make a note on your map, change the 3 to a 1 and the 1 to a 3.
We've corrected the official exhibits for the record, thank you.
Okay. Okay, do you have any information for the board to review?
Yes, I'd like to actually read my
Okay.
document.
Brandon, get those.
The subject property located at 3231 North Ventura Road, Oxnard, was purchased as a private sale on the secondary market on April 30th, 2012 for $215,000. According to the notice of enrollment of escape assessment, this property was assessed a value of $265,200 for years of 2014 and $266,044 for assessment year 2014. The base year assessed value is significantly $50,200 lower. It's 23.3% lower than the purchase price of the subject property in April of 2012. I'm requesting to change the assessed value of subject property to equal the purchase price. In connection with this request, I'm providing a set of documents in my binder, so you can review them and see. So, first listed list of 11 properties sold on the secondary market between January 23 of 2012 and July 23rd of 2012 in River Park area with 2-mile radius of the subject property. So I did research by using MLS database. So as you can see by that spreadsheet, you can see prices of the houses, you can see price of a subject property house and compare them. I also did calculation of weighted average price of similar properties based on the approximation of square footage to match the subject property. It's step 4 calculation in the binders. You can see it actually. Weighted average price for houses of between 1,500 square feet, 1,069 square feet, it's $2,600. Even if I'm including additional houses, with actually more square footage, I'm still getting price less than $1,500. In tab 7, I'm including a history chart provided by Zillow website. It's actually a very common website to do marketing and house researches. And you can see the subject property value price actually dropping down significantly. It's normal market price for this house. Therefore, I think assessment value should be not more than subject property sales price of $215,000. I also should note I deliberately excluded 3 new built houses, which we actually already discussed before with assessor's office, because it's wrong to include new built houses from that calculation. It's not a primary house, it's not a secondary market. For that reason, I think I'm continue to request to change subject property price value to $215,000.
Okay, thank you.
Mm-hmm.
And to the clerk, we'll mark the applicant's exhibit as number 1, the booklet. Are there any questions from the assessor to the applicant?
How many of these comparables that you're showing us are actually from your neighborhood?
Excuse me, say it again?
How many of the comparables that you're showing are actually from your neighborhood?
Well, I did a search for MLS list in 2 miles radius to look for the similar houses in the River Park, especially in the River Park area. If you can see, in my spreadsheet, it's only River Park houses in 2 mile radius. So, and I also excluded affordable houses from my calculations because it's not fair. So no new houses, no affordable houses. So normal sales from January to June.
Once again, can you identify from your neighborhood any of your comps, from your exact neighborhood? I realize these are all from River Park, and maybe there's confusion for you. That's not your neighborhood. Your neighborhood is very distinct because there's actually, I'm guessing, 6 to 10 now, different distinct neighborhoods in River Park. So how many of these comps are from?
I can't do it right now. I need some time to actually go through the map and look for houses on the map. I can't say it right now. But again, I did my research. And to do such research, to do a weighted average, actually I need to have significant number of houses. I can't just took 2 houses and base my calculations on 2 houses. That's completely wrong. It's not mathematically ethical to do it.
Okay.
Again, just to compare, I do have a Zillow research tab showing price for this house, market price for this house. And you can see it's a very low. It's hit at bottom in 2012. So if we're talking about market price, this is a market price. If you buy a new house, it's a new house. If you buy a new car, it's a new car. You can't say new car which has been built 5 years ago, it's still...
Right. Okay, any further questions from the assessor?
No more questions from the assessor.
Sorry.
Okay, that's quite all right. Questions from the board or from council?
I just have a question. You used the word secondary market. By that, you mean a house that's not originally new from the builder, but
Yes,
has been
exactly.
sold twice or more?
Yes.
Okay.
Since your home was not on MLS, how did you come about finding your home?
Well, it wasn't so hard to do because, you know, we have friends and I asked, hey guys, have any of you have a house which we can purchase? And we looked for market price and came to the buyer and we agreed to that price because it was market price on that time.
Okay, so
How come the buyer, you know, ask for less? It's not good for the buyer and for the seller. I can't ask for a bigger price because in my interest to buy as lower as I can. For the seller is buy as much as that seller can get from me. So that's the thing.
Okay, so
and to save money, we decided not to go through a whole official process because it's kind of...
Right, so
What's the reason? If I have
both you and the seller agreed that $215 was an appropriate value?
Yes, yes.
Did you take into consideration that the seller was not going to be paying realtor fees in that? Did you sort of do any math about that? Because that tends to tack on the price, you know?
Well, I'm not fully aware about all taxes needs to be paid in such situation.
Because typically when someone sells a home, they pay the realtor fees. But if they don't list it for sale, they don't pay those realtor fees, which is a benefit to the buyer typically.
Well, another thing, before we start doing this, we looked for the actual MLS listings for that area and to check the actual price, what's the good price and what's the bad price. So I do have a copy of such listings in, in my database.
And did you finance the transaction?
No.
You
It
paid
was a
cash?
land contract, so...
Right. Did you have an appraisal when you purchased it?
No.
You did not have an independent appraisal?
No, we took it as is, without, like it was, without any changes to the house. And so
Okay.
Okay.
no remodeling, no constructions, nothing, just as it was presented.
You had mentioned your database. You're referring to the MLS?
Yes, I do have a printed MLS on April of 2012 with list of houses available on the market, so I can see the actual price on the market and see, is it good for me to buy, or I can ask for the less money. So I don't have it with me right now, but I can present it if it needs to be.
Okay, yeah, I have some of your MLS sheets in your packet here after tab number 3. Are you a real estate broker yourself?
No.
No? Okay.
No, not at all.
Okay. And one question under, in your exhibits here under 3, there's a property 3114 North Ventura Road. It's the very first one after the number 3.
Yes, I can say it.
Okay. I'm looking at that client summary report, and over to the right, it says lot square foot, approximately 900 feet. So that's a condominium, correct?
Well, pretty much most homes in River Park, it's a duplex, threeplex, fourplex, or sixplex houses. So it's the same thing here. So it's one structural building with 3 different units.
Okay. So does your house have a backyard, front yard,
No,
side yard?
No, we don't have. It's a sixplex unit, one of 6 units.
Sixplex.
You actually can see it on the photo, on one of the photos presented by Assessor's Office.
Okay, yes, we have it here on the
You
assessor's
can see it.
exhibit.
It's just one small left or right side of 6 units in the middle.
Okay. Okay. Any further questions?
I don't have any, no.
Council, any questions? And you mentioned you bought the property under a land sale contract.
Yes.
Okay, and so that means the
We
seller,
didn't have enough money to actually buy it, so we had a credit from the seller for $30,000. So I had to pay that $30,000 in a few years.
okay,
And
gotcha.
it was cheaper for me than go to the bank and ask, because, it's just,
Okay, so the seller carried the financing. Okay, gotcha.
yeah, you have copy of that contract at the end of the,
Yes, you've given us a lot of information to review. Thank you. All righty. Hearing no further questions, council, would it be advisable for the board to deliberate in closed session on this with you?
I believe
To,
they should each have one opportunity to do
Yes.
their closings, and since the
Yes.
assessor took the burden of proof, they would
Yes.
be the final to make their closing statement. First, Mr. Shirtkova would
Yes.
start.
okay. I
Yes,
understand.
right. Okay, but I'm just asking, will you be available for the board to deliberate on this
Yes.
after the hearing? Okay, all right. Okay, we'll have anything in closing remarks from the applicant?
Well, I would like to request to keep actual base price for $215,000 as the sale price for this land contract.
Okay, thank you. And anything in closing from the assessor?
Yes, thank you. Just to remind the main act, we have a rule called Rule 2 that dictates market sales, and when they're non-market sales, we do have to look at comparables. We did not look at all of the applicant's data, but what we did find was not from his neighborhood. We'll share that with you. All of our comps are from the neighborhood, and there are distinct neighborhoods in River Park. It's not a block. And there's reasons sometimes when you pick comparables and that particular tract has low-cost housing, it affects the market properties. And other places that don't have low-cost housing have a different open market result. And that's what we believe the case is here, and that's the summary of our case. Thank you.
Okay. All right, hearing nothing further, would it be agreeable with you to meet in closed session after we hear the other hearing so that we don't keep the audience waiting and discuss this after? Okay. So we will take this application under submission. The board will meet with the council's office representative in closed session, and we will come up with a determination of the value, and you will receive what's called written findings of fact from the council's office, And that should be within about 45 days that you do the findings of fact.
Of when the minute order issues.
Once the minute order issues. And I know there's two applications here, but we have to discuss the first one first, and then the other one will fall into place based upon the mathematics of what our decision is. So we will keep that in mind as well. So if you would like to wait, the other case is probably going to take a good couple of hours. I don't know if you would like to wait until we have time to deliberate, or you can call the clerk's office probably within the next couple of days to hear the board's decision and then follow up with the findings of fact, if that's agreeable with you.
Okay, I think about, see how it goes here, so maybe I will wait.
Okay, very good. Okay, so
And
we
Ms.
will.
Little,
Yes.
just for clarification, this was a window period transfer, so if you do determine that the value on the roll is incorrect, we'd need to apply 2% to the base value that you'd make a determination on for 2013. And what does that come out to? 0.454% for
Okay.
2014.
Okay, 14. All righty. Okay. All right, we'll take your application under submission, and we thank you for your testimony, and we thank the assessor for his testimony, and we'll try to move through the rest of our agenda. Thank you.
A question for the clerk.
Yes.
Is the clerk now going to collect the payment for the findings from Ms.?
Yes.
He just has to get it to me before the board makes their decision, so if you, do you need a minute to get a check? Or?
Yeah, I'm going to the bank to do check.
Okay, so just get it to me before we're done today, and everything should be all right.
Okay. That's under submission. All right. We'll let you start getting settled in the podium area here. Let's just take a 10-minute break before we head into the next case.
All right, we're back on the record.
All right, we're back on the record. Cases 12 through 25.
Yes, I'll
If
read
you-
those application numbers and various applicant names. There's slight variations. Item 12 is for application number 13-11278, applicant ASN Thousand Oaks Crest LLC. Items 13 through 17, applications 13-12124 through 13-12128 are for ASN Ventura Colony 1031 LLC. Items 18 and 19 are for application numbers 13-12129 and 13-12130 for applicant ASN Ventura LLC. Item number 20, application 13-12131 is for applicant ASN Thousand Oaks Plaza LLC. Items 21 through 23 is for applications 13-12132 through 13-12134, applicant Tishman Spear Archstone SMI. And last, items 24 through 25 is applications 13-12186 and 13-12188 for applicant ASN Ventura 1031 LLC and others. That is all applications covered by this proceeding. And to clarify for the record, the assessor's office has requested findings of fact, and we will transfer payment from them after the hearing.
Okay, so noted. Thank you. Can we get an overview from the assessor's office?
Yes, this is a penalty assessment case, and in penalty assessment cases, the assessor has the burden of establishing the basis for imposition of the penalty assessment. If we turn to page, oh, you don't have the... Basically, this was a change of ownership or control of approximately 106 properties throughout the state of California. 14 of those properties reside within Ventura County. The State Board of Equalization received a BOE 100B in the name of Archstone Properties, AKA the Lakes Holdings, dated May 20th, 2011, and this reported the series of transactions. The State Board of Equalization analyzed the information and determined that under Revenue and Taxation Code Section 482B, a 10% penalty applies because the applicant did not file the required form within 45 days of the change of ownership. The assessor valued the properties, applied the penalty, and we're here now. If we turn to page 6 of Exhibit A, you'll see the form that was submitted. And at the bottom, it was signed by Ms. Mosley on May 20th, 2011. On page 8, this was part of the analysis by the State Board of Equalization. Showing that the actual transfer occurred on December 1st, 2010, and listing all the properties that were affected by this transfer. There's 2 categories. Category 1 are changes of ownership. And Category 2, which starts on page 10, are changes of control. And on page 11, the SBE basically said that under 482B, the penalty does apply because of failure to file in a timely fashion. On page 12 is a letter, or a portion of the letter, the last page of a letter that Ms. Mosley included with the analysis, or with the form when she sent it to the State Board of Equalization. And in the yellow highlight, it shows, the restructuring was overseen by the financing department, and it did not occur to the financing department that the restructuring might require a filing with the State Board of Equalization. So the question now becomes whether or not it was reasonable cause. There obviously was no willful neglect. I've got the various revenue and taxation codes, 480.1, 480.2, and 482 and 483 attached. On page 23, it's 483. Under C, the Assessment Appeals Board may abate this penalty if it was due to reasonable cause and not due to willful neglect. Beginning on page 25, the Franchise Tax Board of California basically published this law summary regarding reasonable cause and outlines about 7 or 8 reasons why or when reasonable cause does exist and when it does not. In this case, it was a situation where the finance department did not know that they were supposed to file the form. And if you'll notice under, where is it? Basically, not knowing what the law is or not knowing that they're supposed to file is not reasonable cause.
Page 25.
Page 25, 6, and 7.
Okay.
Under section 2 on page 25, says, even if the taxpayer is unaware of a filing requirement, ignorance of the law is not an excuse for failing to file a timely return. And to go a little bit more in depth as to reasonable cause, I'd like to submit Assessor's Exhibit B.
Okay.
This is a Supreme Court ruling issued in 1985, the United States versus Boyle.
Thank you.
The gist of this case was a taxpayer failed to file on his state taxes after his mother had passed away, and the law is clear that you have 9 months to file. He had provided all his information to his attorney, and the attorney miscalendared the information and it ended up being filed 3 months late. So the taxpayer went ahead and paid the penalty and then filed in federal court to try to have the penalty abated, and federal court felt that was reasonable cause and removed the penalty. The IRS then took it to the appeals court, and the appeals court upheld the lower court's decision. The IRS then took this to the Supreme Court, and if we turn to on page 1, almost down to the bottom of the page, the second to last yellow highlight, the federal district court said the penalty was unjustified because his failure to file the return on time was due to reasonable cause, i.e. reliance on his attorney. The district court agreed and granted summary judgment for the respondent, and the Court of Appeals affirmed it. Held by the U.S. Supreme Court, the failure to make a timely filing of a tax return is not excused by the taxpayer's reliance on an agent, and such reliance is not reasonable cause. That's in the last yellow highlight on that page. So on page 2, the second yellow highlight shows that the Supreme Court actually reversed the decision. And the next yellow highlight below that, the Chief Justice delivered the opinion of a unanimous court. So it was not even a split decision on this. And throughout the body of this, it actually discusses penalties, civil penalties, reasonable cause. If we look at page 4, the first yellow highlight, the purpose in prescribed civil penalty was to ensure timely filing of tax returns to the end that tax liability will be ascertained and paid promptly. The relevant statutory deadline provision is clear. It mandates that all federal and state tax returns be filed within 9 months from the decedent's death. And the second yellow highlight, to escape the penalty, the taxpayer bears the heavy burden of proving both the failure did not result from willful neglect and that the failure was due to reasonable cause. I don't think there's any doubt here that there was no willful neglect, but the question now becomes whether there's reasonable cause or not. On page 5, the first yellow highlight, other courts of appeals have dealt with the issue of reasonable cause for late filing and have reached contrary conclusions. The next yellow highlight, it goes into the government having millions of taxpayers to monitor, and our system of self-assessment and the initial calculation of a tax simply cannot work on any basis other than one of strict filing standards. Any less rigid standard would risk encouraging a lax attitude toward filing dates. And on the next yellow highlight, showing that Congress has placed the burden of prompt filing on the executor, not on some agent or employee of the executor. The duty is fixed and clear. So there's an obligation here by the taxpayer to file timely no matter what. The fact that all of this was controlled by the finance department within their organization does not excuse the fact that they didn't file the form in a timely fashion. And on page 7, the yellow highlight on this shows that the Internal Revenue Service has articulated 8 reasons for late filing that it considers to constitute reasonable cause. These reasons include unavoidable postal delays, the taxpayer's timely filing of a return with the wrong IRS office, the taxpayer's reliance on the erroneous advice of an IRS officer or employee, the death or serious illness of the taxpayer or a member of his immediate family, the taxpayer's unavoidable absence, destruction by casualty of the taxpayer's records or place of business, failure of the IRS to furnish the taxpayer with the necessary forms in a timely fashion, and the inability of an IRS representative to meet with the taxpayer when the taxpayer makes a timely visit to an IRS office. I don't believe any of that actually occurs with this case. Another one. So I have a few more yellow highlights in here. There's one in here that actually discusses the fact that other cases have ruled differently, and the Supreme Court feels that there should be reasonable cause presented in most of these cases that fall under specific headings. That's all the evidence I have.
Okay. So it sounds like the applicant has the burden of proof. And they'll take it away.
Take it away, okay.
Yes.
Doing questions of the assessor's presentation?
Oh, okay. I'm sorry. Any questions?
No. No
Council?
questions.
I don't have any, no.
I have none yet. Okay, we'll hear from the applicant.
Madam Chair and Board Member Sisk, and Council, thank you so much for your time. This case has been continued several times due to my health issues, and I appreciate the patience the board has shown on our behalf. I think you have the exhibit she just handed out. If you would unclip the first page, I simply did that so you could put that in front of you as we page through the actual exhibit, which is stapled together.
Okay.
And just,
Let me just tell the clerk, we'll call the entire packet Exhibit 1, if that's all right. Okay, go right ahead. I'm sorry.
I agree with the assessor that there was no willful neglect, so we won't spend a lot of time on that. But I do want to outline for you the basis for the reasonable cause argument that we're going to make. And to do that, I do have to give you a little background. Archstone, Archstone is a large, or was a large REIT. It's one of the largest investors and developers and operators of apartment communities in the United States. And of course, Lehman is infamous for the crash, and Lehman was involved in this transaction. At the time of June 2011, the company had ownership positions in about 434 upscale apartment communities. And the ownership structure of Archstone in 2010 was the result of an acquisition of the Archstone portfolio in 2007 by Tishman Speyer and Lehman Brothers Holdings. And it was for $22.2 billion. And what happened was, with the economic issues that occurred, the lenders in 2010 demanded that the debt be restructured. So there was a very, very complex, intricate restructuring of the debt that took place because the lenders insisted. And it was overseen by the financing department, just like any other entity that would go to refinance or to get another mortgage. So you can imagine this is a large company, and sometimes they operate in sort of separate compartments. So the financing department was taking care of this. It is a sophisticated company, so they did do due diligence, and they solicited advice from a large property tax entity, DLA Piper, who does significant work across the United States. And what happened was that they gave the proposed transaction structure to DLA Piper and had them review state by state the effect or impact of this transaction for property tax purposes. If you will look at your Exhibit 1, pages 1 through 4, 5, let's see, 1 through 6, I didn't give you the total agreement. Of course, that's privileged and confidential, but I wanted you to just understand the scope of this transaction. This is the master restructuring agreement, and you can see from the table of contents and the list of exhibits that this was a massive undertaking, and they spent months on it. If you look at page 7, this isn't meant for you to sort out, but I wanted you to see the org chart. And this is the pre-restructuring, 7 and 8. And then if you turn to 9 and 10, it's the post-restructuring. At the very top of that, you can see the Bank of America. Actually, turn to page 10, and it gives you a good idea of the lenders. And you can see that there's varying classes of the interest, and needless to say, very complex, very sophisticated, very, very intricate. We were not involved at any time with that transaction until after the fact. And this is how it went. DLA, in a very detailed attorney-client privilege document that I will not submit to the board, but I will quote from, said this about the transaction after they had outlined everything. Following the steps outlined above, the bank lenders will own 100% of the preferred interest in Archstone Parent and 91.995% of the common equity interest. The preferred interest in Archstone Parent is supported by Archstone's parent's preferred interest in Holdings One and the Lakes. The effective subordinated equity interest of the bank lenders in Archstone REIT changes from 86.87 to 85.39%. The effective subordinated equity interest of the bank lenders in Holding One changes from 93.586% to 91.995%. As a practical matter, based on current valuations, the preferred interest in Archstone Parent represents 100% of its current net value. In other words, no change in control, no change in ownership. So in a very prudent and ordinary course of business way, this sophisticated entity solicited advice. This is not relying on somebody to make a filing by a deadline. This is about soliciting the advice. And just because we just heard from the assessor, if you turn back to his exhibit, page 6, second paragraph, highlighted portion. Courts have frequently held that reasonable cause is established when a taxpayer shows that he reasonably relied on the advice of an accountant or attorney that it was unnecessary to file a return, even when such advice turned out to be mistaken. And the second highlighted in that same paragraph, this court has also implied that in such a situation, reliance on the opinion of a tax advisor may constitute reasonable cause for a failure to file a return. What happened next was our firm had been retained in 2007 to file and prepare and file all the BOE 100B statements for that initial transaction in 2007, unrelated to this. So we had somebody named Rob Kultiska, who worked at the company in the property tax area. He was the one doing the groundwork of filing appeals and our interface for that time with the BOE 100B statements. So he happened to call me and say, I just heard that they went through with this refinancing, and I wondered if we needed to file BOE 100B statements. And I said, well, he says, I just mentioned it to Tom Reef, who was the tax guy, who was sort of the liaison between the financing department and the property tax guy. And Tom Reef decided that we should have a conference call because Rob felt sure that there probably was something triggered because Rob was their guy who dealt with California. Archstone's huge, they have Massachusetts, they have lots of different states. So I said, I can't tell you that unless I look at the documents, and it took several weeks, and they got us the documents, we reviewed them, and we came to a different conclusion. If you, I think I have to give you the whole BOE 100B filing because it's not in the assessor's case. I thought he would give you the whole thing. So if you can bear with me for a minute, I want to show you, there's one page that you need to see.
Okay.
Oh, I only have 6, that's kind of a problem. Oh, no, I do, I have 7. I have it.
Thank you. This is applicant's exhibit 2.
Yeah. I'm sorry, I wasn't planning on handing this out, so I didn't bait stamp it. But if you would turn to about 8 pages in, it'll be labeled page 1, and it's a Schedule A 2B. Let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10 pages in. This is our description of the transaction that we attached to the BOE 100B. And if you follow that along, you will get to page 5 of this segment. Turn to page 5. And you can see the summary of ownership changes for Archstone debt restructuring, that table. Look down and you will see at every step we analyzed, is there a change? No. Is there a change? No. Why not? Because of this rule. Is there a change? No, no, no. In step 4, there was a change, but it was exempt because of the co-ownership rules. But then, or it's not step 4, I think it's step 2. But then because there was another transfer or change in the way that they did the transaction, the co-owner rule came into effect. And that's the step in the transaction that we identified as causing a change in ownership change in control that needed to be reported. We won't go through the whole thing, and you don't need to read the whole transaction. I just want you to understand that the history of why there was a BOE 100B statement filed is because when this Rob just called me sort of off the cuff, we said we probably should look at that. And they had relied on their very expensive analysis, but we said, no, we really think there is a change. Under the rules, it was a 45-day period to file the change in ownership. Of course, they missed that because they called us in late March. I did want to point out to the board, and I know you're aware of this because he pointed it out, I believe, assessor did, that they changed that statute very quickly to amend the 45-day period to 90 days, which arguably is a recognition of the fact that it was just too short and people needed more time, and these things can be very complex. Even so, we would have missed the 90-day if that had been in effect. But I do want to share with you a little bit about the legislative history of this provision. When Senate Bill 507 was suggested or recommended, proposed, this is what the author said. A property owner's failure to report changes in ownership, willful or not, has greatly reduced the ability of county assessors and the BOE to efficiently process changes. It is time to increase the penalty for noncompliance so as to encourage timely response to requests for information, should the BOE require additional information for processing. This is the really important part. The purpose of this legislation is not to generate revenue for assessors' offices. Rather, the penalty increase is an attempt to encourage timely filing of the change of ownership statement. Taxpayers often view the low penalty as an opportunity to postpone timely filing of the change of ownership statement to delay paying appropriate taxes. The increase in the penalty is an attempt to eliminate the financial advantage of late filing and to facilitate timely payment of property taxes. Clearly, Archstone is not the type of taxpayer that is contemplated by this legislation, as evidenced by the fact that it voluntarily complied with the filing requirement and did not delay upon discovery of its need to submit a Form BOE 100B statement to the state board. After becoming aware that it needed to do that, and after it knew it had already missed the deadline, it could have just not filed because it would have had the penalty anyways. But they decided to endeavor to file as soon as possible, and it did take us 60 days. It was complex. There were properties, and you can see from my BOE 100B statement, the communication that had to go back and forth. It just took a long time. Okay, so what happens now is that the statute, like the assessor said, is about excusable delay. Is there an excusable delay? So the rule is that it can't be due to willful neglect, which clearly it wasn't, and then that there is a reasonable cause. What the assessor is giving you in his exhibit is not property tax law. it's related to the IRS and the Franchise Tax Board. But that's because there's no really good authority in the state board site or, in their database. I looked and I couldn't find anything, so I also turned to the IRS and the Franchise Tax Board. And in order to determine if there's a reasonable cause, it's required that a taxpayer exercised ordinary business, care, and prudence, but nevertheless failed to comply. He must show that failure to file timely occurred despite the exercise of ordinary business care and prudence, or that cause existed as would prompt an ordinary, intelligent, and prudent businessman to have so acted under similar circumstances. And our position is, based on the expert opinion and advice we had received, we acted prudently as any other businessman would have done.
Excuse me, what are you reading from?
That is going to be in a brief that's on page 14 of, so it's got a cite.
Thank you.
In the present case, they really did believe it was like a refinancing, and that's why. But they checked. They weren't neglectful of that, and they were prudent. And the answer they had was, there's really no change in ownership. There's no problem. The thing that tripped them up was that co-ownership rule of 64D. And that also is a self-reporting section, if you know that section. I feel like there are mitigating factors here, and the IRS will take into account mitigating factors when they look for reasonable cause to excuse and to abate penalties. Their sheer size and complexity makes this entity unique. And I know that argument cuts both ways, that you might say, well, they're so sophisticated, they should have got 2 opinions or done something like that. But they're no different than somebody else as long as they're acting prudently and doing what a businessman would do. And it is a mitigating factor. This took months, and a lot of complex and intricate steps had to be analyzed. If you just go back to my table, you can see so many steps in the transaction. They took initiative and filed without any prompting from the BOE as soon as they realized that they needed to file. They volunteered. They don't come in within the purview of what the legislative author was looking to prompt. You might also be interested to know that when the BOE 100B statement arrived, it took several months for the state board to get back to us. In property tax time, the fact that the deal closed on December 1st and we filed by May 20th is very quick in property tax time. We did not hear from the state board, I think, for a year or more. And when I spoke with Julie Warren, she had trouble understanding the transaction. I had to give her subsequent information, and finally, she just said to me in a phone conversation that the transaction was so complex, they really couldn't verify whether a change of ownership had occurred or not. They were going to take our word for it. Literally, that's what she said to me. I also think that there's an equitable argument to be made here in that Archstone did not slow down the tax collector in collecting payment of the taxes by filing this in May. If the reason, as the author of the legislation stated, was to make sure that the information was there so as to not avoid compliance with tax payments, the fact that they were late did not damage or cause any problems for the tax collector, and especially since it only took them 60 days to file. So basically, I am telling you that we believe there's reasonable good cause. I also wanted to point out to you, and we don't have to go into too much detail about it, but in the property tax, in the Revenue and Taxation Code, there's a section 4985.2, which deals with delinquent penalties and cancellation of penalties for property tax corrections, cancellation, and refunds. And it's drafted to say failure to make a timely payment due to reasonable cause and circumstances beyond the taxpayer's control. That is noticeably absent in the provision for abatement of penalties for a late filed change in ownership statement, or BOE 100B. And we can take from that that it's not the higher standard. It's a lesser standard in some ways for the abatement of the Archstone BOE 100B penalty.
Could you please repeat the site?
I can give it to you. I brought it, I don't want to deluge you with exhibits.
And that'll be applicant's Exhibit 3.
That the assessor
Thank you.
kindly included all the other provisions in his exhibit, so I don't think I need to give those to you. Oh, thanks. It's just on the first page in paragraph
Got it.
A.
Thank you.
So our primary position is the penalty should be abated. There are mitigating factors here. We acted prudently in the ordinary course of business. There's reasonable cause, and we think that it should be abated completely. That being said, I also want to address something else, because we're having these hearings all up and down the state, and we're finding inconsistency among the boards and among the way that the assessor, the tax collector, assesses the penalty. So if you will turn to page 16 of Exhibit 1. Of course, you can imagine when Archstone realized that they needed to file this, there was an immediate panic, and we had to give them an estimate of the penalty. In order to do that, I contacted the state board to verify how the penalty was calculated. This is the question and answer sheet from that site, an excerpt. You have page 1.
That's on Exhibit 1, page 16. That's why I'm not, okay.
I'm with you.
So turn to page 17. The front page just tells you, it's printed off the site, so you can see these are the question and answers. If you look at number 32, at the bottom of the page, would special district assessments, general obligation bond charges, and improvement bond charges incorporated into the tax bill be included when determining the amount of penalty? No. The 10% penalty calculation is based only on the ad valorem taxes that are due. Special and general taxes and special assessments that are a lien on the property are not included in the base for calculating the penalty. I asked for clarification, and Lisa Thompson, who is head of the LEOP department up at the state board, confirmed for me that no, it's just the 1%. It's 10% of the 1%. So you take your base, your value for the land and or the value for the land and improvements, you multiply that by the 1%, and it's 10% of that should be your penalty. If you look at the first page that I said was loose, that you could look at while you're looking at the other things, the table that I put together, you will see in column A, that's the penalty notice value. And I've attached all those penalty notices for you subsequent to this. You can flip through by parcel number. It's the backup for this chart. That's why it's substantial. That's what we were notified would be the penalty, the value for that the penalty would be calculated on. And then you'll see in C the actual penalty assessed, and I have those bills attached also. The reason I put B in is so you could see that the total tax rate was used in calculating the penalty, and that's incorrect. So then I go to the base year value land and improvements after column C. Those numbers came from the assessor's office. There were some appeals on these properties, and some were reduced, but the penalty wasn't. So there needs to be a correction. So in the alternative, should you not find that our reasonable cause argument is good, I am requesting that this be corrected. And I've calculated, and I'm sorry there was an error, but I've calculated the 1% tax, the estimated penalty, and then the refund due is the net between the actual penalty that was assessed and the estimated penalty that we show should happen. At the very back of this packet, there is another chart like this from Santa Clara. And Santa Clara did correct the penalty I don't think the board understood the reasonable cause argument. I was disappointed in their ruling, but they at least corrected this. So at a minimum, I'm presenting that to you to show support for the fact that this is done the way that I am telling you that Lisa Thompson told us. San Diego does that way. Santa Clara does it that way. You should do it that way. But, these things take a long time to wind through the various counties, and you're just our second one up. So we're correcting it as we go. Any questions about that? That's a little complicated. I hope it was clear.
I think we're getting there.
You got it?
Okay. Any questions from the assessor?
Well,
Most
just in
important.
case, there's a State Board of Equalization staff legislative bill analysis where they talk about the penalty, and they say taxes on $1 million property are $10,000, and a 10% penalty would be $1,000. So I'm going to go ahead and give this to you. It's just extra since he's having a findings of fact. I think you should probably have it, and it will be found on page 11, paragraph 2.
Thank you. And this is Exhibit 4.
This is talking about Section 480, which is the change in ownership statement that goes to the assessor, but it's the same penalty for both, a LEOP, late filed BOE 100B, or a change in ownership.
Could you please repeat the page number in here?
Page 11, paragraph 2. Before I close, I'm ready to close. I just want to address the letter that was in my submission to this state board that the assessor included in his exhibit. So we'll go to his exhibit. I guess that's probably easier. I said that, but now I can't find it. In my letter that he pointed to, sorry. He highlighted the part that said, the restructuring was overseen by the financing department, and it did not occur to the financing department that the restructuring might require a filing with the State Board of Equalization. Those were my words in submitting this. I told you what happened. This is true. They really didn't think that it needed to be filed. I just didn't give the background that I gave you in this letter. And I just wanted to clarify that. So in conclusion, we would respectfully request that due to reasonable cause, the penalty for late filing of the BOE 100B statement be abated entirely. In the alternative, if you should see that that's not the case, that there be a correction made to the penalties that have been assessed to account for reduced base years achieved with later appeals, and to make sure that it's only the 1%, 10% of the 1%. Thank you very much.
Okay, thank you. Questions from the assessor?
I just want to know, you do not have a copy of the letter that went from DLA to Archstone actually telling them that there was no change of ownership?
I actually have a copy of the memorandum, but it's privileged, and I'm not going to submit it. Well, I'll read it to you again. It's in the record.
Could you identify it by date or something that helps us identify it in discussing it in the findings?
June 17th, 2010, memorandum, and the ray line is Archstone Debt and Equity Restructure - Transfer Tax Analysis. It covers more than just transfer tax. It covers property tax ramifications for Colorado, Florida, Germany, Georgia, Illinois, California, Arizona, New York, New Jersey, Maryland, Massachusetts, Oregon, Philadelphia, Texas, Virginia, and Washington. It was extensive.
The assessor has no more questions.
Okay. Any questions from the board?
Nope.
No? Council? No? Okay. All right, we'll hear from the assessor. Anything else?
I think
the
you can do it. I can go first, then you, and then I could do or you could just go first and I'll go last.
Basically, we have all the information that we have. The State Board of Equalization required that the penalty be placed on the roll. As far as the overtaxation of the penalties, that's more of an auditor issue than it is an assessment issue. So that needs to be taken up with the auditor's office, not with the assessor's office, as far as calculation of that tax. It's our opinion that there's no reasonable cause here. Yeah, it was a complex issue, but they spent months working on it prior to actually doing it. They had, 7, 8 step transactions involved with this. And all those steps occurred on the exact same day. So it was all put together months in advance, and over a period of time, there was no reason for them not to file the form in a timely fashion.
Okay, closing from the applicant.
In response to the assessor's comments, it didn't happen all on the same day. It happened in the same time frame, but they did the mergers and the proportional interest, changing method of holding title first. And you can look at it. You can look at the memorandum. I think the most telling thing is in the assessor's own information that he submitted, which is reasonable cause does exist if you rely on the advice of an attorney or an accountant for an expert opinion. This was not the same facts as what he gave you in his Exhibit B. This was not about, do we have a deadline to file? This was, do we file? Do we need to file? So we believe that there was reasonable cause, and in the alternative that the penalties have been assessed incorrectly. And when I did try to talk to the auditor says the assessor tells us what to do. So I'm not sure how that works, but I would appreciate something from the board if that's the case. The cleanest way, of course, to deal with this is to abate the penalties. And we so request respectfully.
Okay, thank you. Thank you.
The assessor would like to make one more comment regarding the letter. It's not being produced as evidence as far as them getting bad advice from any other firm. So we can't accept that. As far as we going over the maximum assessment, I believe that should be corrected.
Thank you.
Okay.
I don't know what to do. I could redact this. If that's a hiccup, if you can give me some time, I could give you the front page redacted. I can redact it. It's just so lengthy, and I thought reading it into the record would be acceptable.
If maybe with the help of the clerk's office.
Would this qualify as a trade secret where we could seal the record, or?
Well, I believe it's attorney-client privileged communications, not the nature of a trade secret. So
Yeah.
if she wants to claim privilege for the remainder of the letter, it would still be helpful to see the redacted portions.
So maybe.
Well, your testimony is evidence,
Yes,
but
it
it's
should
always
be.
better to have something in writing. And if
Okay.
you can redact it, that'd be great.
Well, maybe if we could take a short recess, then we could do that, and then that'd be the final thing, and we'll be done.
Sure.
If you can help me, Brendan.
Okay.
So,
I can, I just need
One copy
to,
would probably be sufficient. We just have to have one copy for the record.
I just need a copy machine that we can redact,
Okay.
you know.
Oh, you need to make a copy and then.
Yes.
send a copy.
Yeah, I'm
Well,
not going
why-
to give you I can't.
Right.
It's not mine to give.
Why don't we do this? We do have a closed session on a prior case. Why don't we go into closed session and take care of that, and then we'll come back and
And I'll have this
you'll be
for you.
ready. How's that? Okay, we'll be off the record for closed session for about 15 minutes. Okay, we are back on record. We're discussing agenda items 12 through 25. And the applicant has provided us with a redacted copy of some information, and we'll mark this as applicant's exhibit. Is it 5, Brendan? Number 5. Okay, if you'd like to go ahead and just explain what we have here on the record.
Oh, you have an excerpt from a memorandum that was prepared analyzing the transaction for Archstone that applies to these appeals. And it was attorney-privileged information, so we redacted it, most of it. But you have the paragraph, the pertinent, relevant paragraph that I read into the record, indicating that the conclusion was different than the one that we came up with on a subsequent look at the transaction after the fact.
Okay, very good. Right, so we'll mark that as number 5.
I have nothing
Okay.
further, unless you have questions.
Yeah, are there any questions from the assessor to the applicant?
I just want a minute or so to absorb this.
Sure, okay.
Chair Little, I just want to make sure the chair was aware. I'm not sure exactly which party was established has the legal burden of proof, but by the property tax rules, the board has to have the last word of the discussion come from the party that has been charged with the burden of proof. So I
Right.
just want to make sure we don't get into a legal technicality there, because I'm not really sure who has the legal burden of proof, but they get the last word. whatever that
Yeah,
means.
the assessor
I
has the
think-
burden of
Yes.
approving the
shifting.
imposition
Yeah.
of the assessment. I believe the applicant actually has to prove reasonable cause and not willful neglect.
True,
So-
correct.
So
Okay.
after we substantiate the actual penalty itself, the assessor's really out of it.
Okay, so the burden is on the applicant.
Hopefully I met that, but I'm done, unless you have questions.
Okay. We'll just give the assessor a couple minutes to review the document.
What I've read on Exhibit 5, there's nothing in here that says that there was no change of ownership and that there's no reason to file any paperwork on it. I'm not seeing where they advised the applicant to not file the form, or that there was no change of ownership.
I put mine away. Can I look at yours? This is, the paragraph I read is the one that says, I hope I did the right one. Yeah, this is, they went from 91 to, or 86 to 85, which is not a change in ownership, 93 to 91. So it's implicit that there, I didn't copy the rest of it. I'm giving you what their conclusion was, that there really was no change because there was no change in control. Yeah, thanks. Anything else?
Not for
Nope.
me.
No?
Thank you
Okay.
for your time.
Okay.
Thank you.
Thank you. Nothing further from the assessor?
Nothing from the assessor.
Okay, the hearing is now closed, and I'm sure we'll need some time to set up, to meet with council in closed session regarding this. Perhaps when you're ready, you've digested a lot of it and we've reviewed it, we can get back together and have a closed session hearing with just us.
I'll let the clerk know when council's done whatever research to fill in any points and is ready to meet with the board members on this case.
But I would suspect within 30 days.
Depending on my other litigation responsibilities, I'll, endeavor to do it while memory's still fresh.
Okay, and then council will communicate with the clerk, so if you want to check with the clerk and
Okay.
see where we're at, and we'll get back together again and have just a closed session, not a hearing.
And
So-
issue a decision and findings?
Yeah, we will meet, they will deliberate, make their decision, and at that point, after they make their decision, I prepare the findings.
Okay,
So to clarify for the record, the decision becomes final when the clerk issues it in writing in the form of a minute order, which would be after the board completes their deliberations. and findings of fact would be issued 45 days after.
45 days after, okay, thank you.
But under the property tax rules, if the clerk does not issue a minute order, the board can just report its findings through a findings of fact and actually has a longer period.
That's right.
It's my understanding that one of the parties has to specifically request that, so is that what the parties are requesting, that the decision become final?
It's up to the board if the board wants to
Okay.
let the parties know through minute order with findings to follow thereafter relatively shortly in 45-day period, or if the board wants to just announce its findings through the formal findings of fact that the board,
Okay,
that's a board policy call.
That's why I was asking, because that's normally how I see it.
Okay, thank you.
I rarely see a
Any
minute order with findings.
Any preference
after.
with you? Okay, well, we'll issue our decision in the findings, if that's all right with you.
Excuse me?
So our decision will come through via the findings of fact.
It's up to you as a board if you want to give the parties, which has been up to now, board practice, a minute order through the clerk letting them know which way it came out without the full board legal analysis. But if it turns out it's a complicated, long, time-consuming process to prepare the findings, you can buy your counsel more time by not issuing the minute order through the clerk. Then we have a longer period actually to prepare the findings. We aren't triggered by the issuance of the minute order
Gotcha.
to adhere to that 45-day deadline.
Gotcha. Okay. All right.
Thank you.
Well, thank you, and thank you to the assessor. So these applications are under submission for further deliberation. Is that okay with you?
Yes, I have note that the matter is taken under submission for decision at a later date, and the decision will become final upon the issuance of the findings of fact.
Very good, thank you. All right, and while we were off record, the board was in closed session, and we were discussing agenda items 57 through 58. And that's applications 14-11468 and 14-11469. And I believe we're ready to issue our decision on that. I guess I'll make the motion. I move to sustain the assessor's opinion of value. To have a second?
I second. We sustain the value of 260.
All right, and so for the second case, would you like to direct the clerk to schedule a evaluation hearing at a later date?
No, the second case will just get factored forward based upon the base year value established.
Right, but the board didn't make a change to the value, right?
No, we
Correct.
did not.
Okay, so the applicant now has rights to a decline in value repeal on the subsequent application. I'm not sure they want to pursue that or not, but that case is technically still open as a decline in value appeal. So I'll coordinate with the applicant what they want to do. They may just decide they want to withdraw it if they were only going after the base year.
Okay.
Does that make?
Well, yeah, decline over the last 3 is going to be hard to prove.
Right, I mean, because the board hasn't heard any evidence on the decline in value for the subsequent year, so the board can't really make a ruling on that.
Yeah,
if
we
this
have no
kind of
evidence.
Remains out there.
Mhm.
If the rules allow for the board to continue and the clerk to set up a date, so if the board just wants to continue application 14-11469, and then the clerk will work with the applicant. If they decide they don't want to go forward with it, I'll just have them submit a withdrawal and not have to worry about it. If they
Yeah.
want to go forward with the decline in value, then I'll set up a future evaluation hearing.
Okay,
Okay.
yeah. Yeah, that's probably the safer way because we did not hear any evidence. Okay, so that's the second application, 14-11469. We'll continue that one to the February 29th meeting. Is that,
Just continue to a date uncertain. The clerk, technically under the rules, all dates are at the discretion of the clerk, so if you just continue it, I will work out the date with the applicant. You don't have to.
Okay.
The way we do business is to order a date, but because the applicant's not here, I'll work with them
Okay.
more abstractly to work out the continuum.
Okay, appreciate it. All right, I move to continue to a date undetermined, application 14-11469.
I so move. Or second.
Second.
All right, hold on. All right, now it's ready for you to vote.
I'm going to vote on yours. Hearing no objection, motion carries.
Mr. Mayor, just in case there's usually questions on the stipulations, that's why I just wanted to
Yeah.
catch you before you walked out.
Okay,
All right.
we've got item 62, the findings of fact.
Yes, this is now the second time we've placed an item like this on our agenda. It's kind of still in the working out stages of how we're going to do it. These findings of fact, item 63, we only have one, were issued in a period where there was no board meetings. So in order to meet our legal requirement to issue them within 45 days of the hearing, we communicated with the board members by email and then mailed the findings of fact with a cover letter conveying the approval to the applicant. So that there's no appearance of things going on behind the scenes. We placed them on the next agenda so that the board could formally acknowledge that the findings of fact were issued. So the clerk is just requesting a motion to receive and file item 62, which is all findings of fact issued recently.
Okay, so moved.
I second.
All right.
And you want to vote?
I just manually put it in. Sorry. All right. And then next
And
we have,
63?
so 63 is covered, so now we bounce to 64.
Okay, so that was that one.
Right, so 64 is the hearing officer's decisions, which is items 65 through 82. And this is for the board to receive and file the decision made by the hearing officer from October 6, 2015. So we just need a motion
Yes.
to receive and file.
So moved.
I second.
Vote.
All right.
Then we have the stipulations. And then we have agenda item 83, stipulations covering agenda items 84 through 125. Would you like me to read the application numbers?
No, it's not necessary. So the board can approve these unless they want to pull one for discussion. The assessor is available for questioning if anybody has a question.
Okay. They all seem signed, sealed, and delivered to us. So I move to approve the stipulations.
I second.
All right, please vote.
Okay, motion carries. Any public comment?
The
Go
clerk
ahead.
would just state for the record that in an effort to improve our public communication outreach, we've recently had informational boards created and are now in the lobby when you enter the boardroom. So if you haven't checked those out yet, they're new. They're right when you walk in the boardroom with some additional instructions to what we provide on the PowerPoint, just to try to make our best effort to provide as much information as possible to taxpayers. So
Very good.
that's a new thing we've done.
Great. Thank
And
you,
the
Brendan.
Screens are down, and we're now at board comments.
Okay. Any board comments?
Nope.
Council?
I just want to acknowledge the clerk's office has been doing a great job in
Yes,
Yes,
improving
absolutely.
systems and
Goodness.
operations.
Oh,
and
yeah.
We really appreciate it.
Yep,
Thank you.
thumbs up. All right.
It's 12:29, if you'd like to
Adjourn.